Hello and welcome. In today's video clip we're going to be looking at the subject of settlement agreements, and within that protected conversations and without prejudice. It's a complicated area, so what we're going to do in this video is first of all covering off some definitions and then looking at some pointers in relation to their use. As always, my aim here is to increase knowledge, and what I'm saying is not to be taken as legal advice. And this video is actually requested by a member of the HR Tutor Facebook group, so if you'd like me to cover other subjects in the future, then send me a message. So starting off with some definitions. So settlement agreements to start with, as the name suggests, settlement agreements are used to settle a particular issue or dispute, usually between the employee and the organisation. They're formally used in redundancy, so you'd usually use a settlement agreement and a COT3 form to end that employment relationship. And they can be used to settle a whole range of issues, and those issues are usually about the ending of an employment relationship. And what someone's doing in signing the settlement agreement is they're waiving certain rights to make a claim. So within settlement agreements, or the topic area of settlement agreements, you also get something called protected conversations. And these can be defined as pre-termination negotiations. So before actually reaching settlement, the negotiations that are carried out. One of the key points in relation to a protected conversation is that the content of that conversation is inadmissible in an employment tribunal. So what that means is that if the organisation is then taken to a tribunal, then the content of the protected conversation shouldn't be considered in the employment tribunal. One of the things that defines a protected conversation is there's no requirement for a current dispute to be taking place. So it doesn't need to relate to a current issue relating to discipline or grievance. It can just be a separate conversation. What you also get in this area is something called without prejudice. A without prejudice conversation is similar to a protected conversation in that it's inadmissible in an employment tribunal. And it actually seeks to achieve the same thing, so it seeks to resolve an actual issue. The main difference here between a without prejudice conversation and a protected conversation is a without prejudice conversation has to relate to a current dispute. So for example, it could be that someone is currently going through a disciplinary process. So without prejudice conversation would apply there. So essentially what we're talking about here then is a settlement agreement is the overall kind of term that's used, and then a protected conversation or without prejudice conversation is something that may be used to facilitate that settlement process. So that's our definition. So if we go on to look at some of the kind of key points in terms of using these in practice. So to start off with then, a settlement agreement, that's quite clear in terms of how they should be conducted. So ACAS actually created a code of practice on using settlement agreements. It outlines some of the key principles of settlement agreements, and I've included a link to the ACAS resources in the description below. So for example, a settlement agreement must be in writing, it must relate to a particular complaint or proceeding, and the individual must have taken independent legal advice. And there's a range of other criteria that need to be met, but those are kind of some of the key things. And like I say, a settlement agreement in itself is quite, as I say, straightforward. It's quite clear in terms of what that's about. If we move on now to protected conversations, so remember, a protected conversation, no dispute needs to be actually taking place at this particular time. And the key thing here is that protected conversation needs to be carried out in a way where no improper conduct is included. So the term protected conversation, it might imply that you can talk about anything within that conversation, and it can be carried out in any way. But it doesn't give organisations a carte blanche just to do whatever they want to do. And this term improper conduct is referred to when things have gone to tribunal. So for example, in 2016 there was an employment tribunal case between Lenlin UK Limited versus Cooler, and it illustrates the kind of conduct which was classified as improper. Again, I'll include the link to the people management article that describes the main points of the case in the description below. But the key things here is that even within a protected conversation, you need to make sure that you're making the individual aware of the different options available, so they're not railroaded just down one particular alleyway. And also given sufficient time to consider what's being put forward to them. So again, they're not being railroaded by saying, well, you've got until the end of the day to make a decision. That would be classified as improper conduct. And if improper conduct has been found to be carried out, then the contents of that protected conversation may be considered by an employment tribunal. If we then move on to without prejudice, so remember this is where there needs to be a dispute taking place, such as a disciplinary. One of the key points here is that if a without prejudice conversation takes place, that should run in parallel but separate to any discipline and grievance process taking place. So what you can't do is, or what you shouldn't do, is you shouldn't be having something like a disciplinary hearing and then within that hearing then flip into doing a without prejudice conversation. The without prejudice conversation should happen outside of that, but it may run along parallel with the actual disciplinary process. And as per protected conversations, you've got to be careful of improper conduct. So again, making sure options available and sufficient time is given. And again, in this case, if improper conduct has been deemed to have taken place, then the content of that without prejudice conversation could be considered by an employment tribunal. So that's kind of some of the key points in terms of those three areas. Now, in terms of my view, it's an interesting area because from a kind of pure HR point of view, you'd say, well, most issues should be dealt with through the organisation's procedures, discipline and grievance being the main one. But the reality is, and you know, if you deal with employment relations issues, you'll find actually things are not always as clean cut as you'd like them to be. So things can get messy and complicated and involve loads of different people. So actually things like settlement agreements, protected conversations and without prejudice conversations, they are tools that are available and can be used by organisations. But as I've given examples of how they might give the impression that you can just have a protected conversation, discuss anything and conduct it in any particular way, when in actual fact there may be times when that is considered by a tribunal, so you still have to be mindful of behaving in a certain way. And the other thing as well, and so this is something I've observed, and this is a concern I know of many people, is that things like settlement agreements, without prejudice conversations, shouldn't become the default position for organisations. So you shouldn't always be settling, because that may mean that you don't then actually deal with and tackle genuine issues in the organisation, and you almost create a settlement culture. As I've mentioned, various resources I referred to are in the link below, such as ACAS, CIPD and people management resources. Okay, well hopefully you found that useful.